This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Thank you for joining us on Insurance Law, everybody. On this episode, we look at key coverage cases decided so far in 2023 in the areas of opioids and forever chemicals. And our guest is no stranger to you. He's Shane Dilworth, Law 360 Insurance Authority Senior Reporter. And back last year, a bipartisan congressional report found that the opioid epidemic cost the U.S. approximately $1 trillion annually. More than 3,000 state and local government entities have been seeking to recover costs of public services associated with opioids from drug manufacturers and distributors. Insurers have been stacking up some victories in the opioids coverage litigation, with wins before the Ohio Supreme Court in the Masters case and before the Delaware Supreme Court in the Rite Aid case last year. And 2023 started off with another opioids victory before the Sixth Circuit in Westfield versus Quest Pharmaceuticals. Shane, what happened in that case?
First off, thanks so much, Scott, for having me again. It's always an honor to work with you. In that case, Quest Pharmaceuticals, Westfield Insurance Company, and Motorist Mutual Insurance Company each filed actions in Kentucky federal court over the duty to defend the drug wholesaler against 77 government suits seeking to recoup the costs of responding to the opioid epidemic. U.S. District Judge Thomas B. Russell awarded summary judgment to the carriers, finding the government suits did not involve covered bodily injuries. The Sixth Circuit, applying Kentucky law, agreed and upheld the insurer's win. In cementing the insurer's win, the Sixth Circuit continued the trend of finding commercial general liability carriers have no duty to provide a defense against government opioid suits.
Yes, and we're not out of the opioids decisions yet. In fact, there's two appeals pending, one before the Ninth Circuit and one before the 11th Circuit, and all opioid eyes will be on those decisions for the balance of the year. The first one, McKeeson is seeking to have the Ninth Circuit reverse a ruling by the California District Court that held there was no duty to defend. What's that appeal all about?
The appeal before the Ninth Circuit involves whether the drug distributor acted intentionally when flooding the market with opioid pain medications and knowing that injuries would occur. Another interesting aspect of this case involves the federal judge's finding that the cases filed by the state of Oklahoma and two Ohio counties were brought because of bodily injuries. That opinion differs from the string of recent rulings in favor of carriers.
It does. And the case before the 11th Circuit is interesting. They're trying to seek a reversal of the Alabama federal court's ruling that coverage was barred by the drug manufacturer's failure to comply with notice requirements and the navigator's policy. Could you fill us in on what's at issue in that appeal?
Absolutely. The interesting thing about this case is it's unlike the typical opioid coverage disputes that I've been following. KVK Tech is a Pennsylvania-based drug maker, and it says that it provided timely notice to its excess insurer, Navigators Specialty Insurance Company, about two personal injury suits that were filed in Missouri. An Alabama federal judge said KVK Tech's notice was untimely and pointed out that it informed its primary insurer about the suits shortly after they were filed. KVK Tech maintains that it provided notice in a timely fashion and that the excess insurer should help with its defense.
Well, Shane, let's transition to PFAS, or forever chemicals, for a few minutes. As you know, forever chemicals have been around since at least the 1940s, and yet these chemicals have only recently become one of the leading areas for civil litigation. There are now thousands of cases that are pending across the U.S. with many eye-opening settlements. There was the 3M settlement for $850 million, Wolverine settlement for $70 million, and then DuPont settlement with its spinoff that resulted in a $4 billion fund for future liability. So the numbers of suits, the numbers of claims, the numbers of dollars involved are just huge. On top of that, you've got more than a dozen states suing manufacturers and others for contamination of drinking water and damaging natural resources. And I have to say, the government regulators in the US came to the party very late. It was only last year, last fall actually, that the Biden administration announced it would designate some forever chemicals as hazardous substances under the Superfund cleanup program. And, they're putting some requirements in with the Natural Defense Authorization Act. And now we have states, several of them, starting to bar forever chemicals. So with all of the underlying liabilities, of course, flow coverage cases, and there will be many more to come. Numerous issues will be presented. So far in a couple of the cases, there's been mixed results on the application of the pollution or hazardous waste exclusion. So normally we might just not highlight a jurisdiction or abstention case, but given the PFAS background, I think the Sixth Circuit decision in Admiral is worth discussing. So let's call upon your expertise to give us your quick take on that.
Well, this certainly was an interesting case, Scott, and I kind of feel the same way that usually I don't delve too much into jurisdictional issues. But the interesting takeaway from the Sixth Circuit's ruling was that it agreed with an Ohio federal judge's decision to abstain from presiding over the case since there was no state court precedent on whether an occupational disease exclusion in Admiral's policy was applicable. The suit really came from a number of firefighters or suing fire decks, claiming their exposure to PFAS and personal protective equipment caused them to develop cancer. And Admiral wants out of defending the suits because they're claiming it's an occupational disease, which is an exclusion in the policy. The appeals court pointed out that the only context where a decision was reached on the occupational disease exclusion was in a workers' compensation dispute that wasn't really applicable to the case that was in front of the judge, so they upheld that ruling.
And it is, correct that the Sixth Circuit didn't do its own analysis so much as affirm what the district judge did, and his ruling was not irrational. But I do have to say, I think it was a borderline call. Here you've got a federal court very capable of interpreting insurance policy language. And one of the lessons from COVID has been the ability of federal courts to interpret policy language and apply them even in a context where there was no prior pandemic anywhere near like this. Yet the courts across the country, federal district courts and the circuit courts, have been able to rule on COVID coverage issues efficiently and correctly. Our thanks to Law 360 Insurance Authority Senior Reporter Shane Dilworth. As always, we thank you for joining us and invite you to tune in or click on for the next episode of Insurance Law.
Thanks for having me, Scott.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.